Okay, so this is Professor Putman, and this is the first time I'm doing this, but this is the 2018 spring semester non-live streaming version of the first exam for African Americans in the law. I have a few students here with me, and we're going to go over some questions and some discussion. And while I'm here, I'll actually log on to the discussion board to see. Have y'all posted? Oh, okay. I was like, don't tell me that it hasn't been working. That will scare me. I'm like, because the exam is tomorrow. About access. Let's see. So just to get it started, as I'm getting everything booted up, does anybody have any general questions? I guess we can separate it into cases, laws, and theories, just to kind of help you guys. So any clarification on any cases?
Well, when I looked at your practice quiz,
Mm-hmm.
which by the way I got every question on,
Okay. You have it with you?
I do.
Okay.
That's what caused me to be very interested in attending here.
Okay.
Trying to find time to make it. But thankfully I have.
No, hadn't even started.
So can I ask questions and go
Can
over
we?
answers?
No, you know what? Never mind. It's fine because I'm hot, and then we can't really hear the TV, so it's fine. But yes.
Like the first question says during the 1600s, difference between black slaves and white immigration service. Now the correct answer was B, but not A and C.
Mm-hmm.
I originally studied
That.
D,
Uh-huh.
right? I mean, E, A, B, but not C, which was white indentured service for either one way. White indentured service for rendered to my English. Because when I saw that answer in the option A and B, but not C, but not C.
Yeah.
So I knew that white indentured service these run away because they ain't locked. They can just go.
Right.
So
They
that's
can
why
blend in.
so
Is really what it
that's
is.
why I answered A and B, but not C. But when we went over it in class, and the correct answer was B, I needed to identify with you when I didn't do it in class, but I can do it here. When you ask questions like that, me, my form of test taking, I'm looking for the trick. And so perhaps I need to not look for the trick. So in looking for the trick, I figured if you got to answer A and C, but not A and B, but not C, sure they can easily run away because they're not locked in.
Wait, I can't remember if this is one of the questions that I had to throw out. Do you remember that? On the
You said
quiz?
you were gonna throw that one out. I didn't show you when you should have been out.
Yeah. I was like, I think this is the one that I threw out. Because you had to think about it. So, because during the 1600s, the difference between black slaves and white indentured servants. One of the differences was white indentured servants could easily run away. One of the answers are white indentured servants demanded to be treated like Englishmen. But what a correct answer is not, or an answer that is not correct is enslaved Africans could easily blend into the surrounding white population by escaping. I don't remember. We did something with this question. Because we taking those back. You don't see it on top of there? Look on top of the water jug. There's one. That's yours then. And there's some coffee cups over there that you can use for it. Nope, I overpaid for those cups. They're going back. What was it? Yeah. That question won't be used. It'll never be used again. It's for. I have the receipt there. I'm taking them back. You can leave them there. Okay. Well, put the receipt with it, please. Okay, so the exam question from the practice quiz that said during the 1600s, the difference between black slaves and white indentured servants, that question will not be used on the exam.
But what about questions typed like that? It's not question.
That was just a bad question, honestly. That's a bad question. I think that's been used 2 times prior to this, and still has been a bad question. I just hadn't taken it out.
Oh,
I'm gonna go to the board, which only one person posted. I hope everybody's gonna do really well on this exam. Brandon Henderson asked, Did Mumbet go to court when she ordered her former slave master to compensate her, or did she get some type of paperwork from her master informing the court that she had been freed? So the answer to that is Mumbet's case was taken to court, hence Mumbet versus Braun versus Ashley, or whatever the title was. But after she was taken to court and they looked at the Massachusetts Constitution of 1780, that court pronouncement stated that persons are all men or born free and equal and free. So did she get any paperwork afterwards saying, hey, this is my court pronouncement and now I'm free? Not sure. This is a case that was in 1781, so they don't get as detailed as we have cases now. But in order for Mumbet to be free, her case was taken to court. So see, if y'all would have had discussion questions, I would have been able to answer them like this. So thank you, Brandon Henderson, for posting that question. Yes, but that's not the type of question that I would ask about Mumbet. I would pretty much ask the question like I asked on number two, which is Mumbet. And I'm looking at the quiz. I say Mumbet 1781. And so to answer that question um, correctly, you would need to know the facts of Mumbet, and you would need to know why Mumbet was decided the way it was decided. So the facts of Mumbet being that she was a slave, she overheard at dinner that there was this new law or this new provision in the Constitution that stated that all men were born free and equal, and she used that to challenge her status as a slave in the court. So that's pretty much what you need to know about Mumbet. You don't have to know that there was a dinner table or dinner party and X, Y, and Z happened, but what you need to know is that she challenged her case or her status based on this law. For pretty much all the cases, know what was the grounds they challenged the predicament in. So, for instance, like the Prigg versus Pennsylvania case, where you have the lady who's living in Pennsylvania. She's a slave, but she's essentially living in Pennsylvania as a free woman. The slave catcher goes to get her. Slave catcher Prigg goes to get her, and he takes her, kind of tussles with her, takes her and her children, and tries to take them back to Maryland. Know what law gave him the authority or what law he relied on to say, I have the right to go get this slave and bring her back. And under that, it was two things. Well, it was a myriad of things. In order for him to even been in court, Pennsylvania has something called personal liberty laws, which just kind of said, hey, if you're going to take a slave, I don't care what the Fugitive Slave Act says, you have to do additional steps, right? So you have the personal liberty laws of Pennsylvania that gave slaves additional rights. And then you have the Supremacy Clause, which states that the United States Constitution and all federal laws are the law of the land, the supreme. So that's why it's called the Supremacy Clause. And so the way that I kind of tried to put this, and I'm going to talk to the camera, but y'all can hear me, right? So the way I tried to get you guys to understand the Supremacy Clause is by discussing how the federal government and how the state government or law enforcement agency deal with drugs, namely possession of marijuana, and how although the state of California, I think the state of Washington, state of Colorado, et cetera, have legalized marijuana to an extent, it is still a federal crime to possess marijuana. So, although Pennsylvania had personal liberty laws that said we can circumvent the fugitive slave law by requiring more than an oath and affidavit to get the slave, we're going to require X amount of more hurdles for you to get this slave. Prigg said the fugitive slave law, which was made by Congress, and remember, laws made by Congress are the supreme law of the land. You don't have to do that. So the Supreme Court of the United States decided that Mr. Prigg, slave catcher, was correct. This fugitive slave law said that if a slave escapes, then you have to present by oath or affidavit that this is your slave, and that's all you need. Forget what additional steps Pennsylvania is requiring because the Supreme Court said this is all you need. Next topic or question, or go ahead. You heard me say affirmation in court. You can use them interchangeably, but know that affidavit or affidavit, as we know now, is a written document, a sworn written document. So it's notarized by a notary.
So the fugitive slave law
Yes. So the clause gave him the right. It says, and I'm glad I'm at my computer because I will read the actual clause. The Fugitive Slave Clause says no person held to, and I will encourage you to actually print out the Fugitive Slave Clause so you can see how it doesn't give you the mechanisms to do things. Because when I talk about the Fugitive Slave Clause and the Fugitive Slave Law, I said the clause gives you the right and the law gives you the mechanism. If you actually read the clause, then you'll see, well, I don't understand how I get my slave back. It just gives me the right to get my slave back because it reads, no person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered upon claim of the party to whom such service or labor may be due. What does that mean? It just says that if you are held to service or labor in a state, you can't be discharged from that labor just by escaping. But if somebody shall claim you, that person who escaped shall be delivered to that person. That's what it says. So it gave the person the right to get you back if you escaped or if you allegedly escaped. So just for a tip, go to the Fugitive Slave Clause, Google it, get a little blurb off of Wikipedia, and just remember the clause give you the right. Highlight that little blurb. No person held to service or labor in one state. Okay, which is going to bring me to the law. I'm sorry, I'm confused. So was it the law that came in 1850 or the act that came in first? So we have three different. We have the clause, which is part of our United States Constitution. The Constitution came about in September of 1787. And after we have this clause, Congress was in session and they said, let's look at what rights we have in the Constitution and make some laws out of those, right? So that's how the Fugitive Slave Act of 1793 came about. And we have Fugitive Slave Act of 1793 and we have Fugitive Slave Act of 1850. Why do we have one in 1793 and one in 1850? Well, first of all, we're amending our federal laws all the time because things change. And a big thing that changed between 1793 and 1850 was the emergence of the Underground Railroad. So we have slaves escaping. So no longer are we going to task private individuals to get our slaves. We're going to task the U.S. federal marshals to get them. We're going to raise our penalties for people that are helping slaves escape. So we talked about the clause, and the clause states that no person held to service or labor in one state shall be discharged from this service, right? And so with that right, they made an act or they made a law out of it. And in this law, it says that when a person held to labor in any of the United States shall escape into any other state or the territory, his agent or attorney is empowered to seize or arrest such fugitive from labor, take him to any judge where the arrest or seizure shall be made, and upon proof to the satisfaction of the judge by oral testimony or affidavit that person so seized has escaped, then it should be the duty of the judge or magistrate to give certificate. That's still me shorthanding that. But you see how it's a difference between the clause and the law? The clause is telling you no person held to service or labor in one state shall be discharged from that labor if you escape. The first law says that, and when a person held to labor escapes, then their agent or attorney shall go before a judge or magistrate in the area where this person has escaped and swear by oath or affidavit that this person that has been seized is a fugitive. So do y'all get those two? One is saying that, look, no person no person who has escaped, no person who is held in a position of bondage shall be discharged from this bondage just because they managed to escape. That's all the clause say. If you're held in bondage and you escape, that does not discharge you from your bondage. The law says that if this person from bondage escapes, the slave master has the right to have his agent, much like Prigg was in Prigg versus Pennsylvania, have his agent or attorney go after that person, seize that person, take that person to a judge or a magistrate in the area where that person was seized, and present oral testimony or present by affidavit that this person is a fugitive. Okay? So we got that? That's probably the most detailed I ever put that. I usually try to simplify it because it can get confusing. Fugitive slave clause, fugitive slave law, fugitive slave law. But the first one, the clause just says no person in bondage. It doesn't say bondage, it says held to labor or service. But no person in bondage shall be released from the bondage just because they escape. And then the law says that it, kind of gives you step by step. If this person has escaped, you can employ an agent or attorney. That agent or attorney can go to the judge where that person has been seized or found. They can deliver oral testimony or deliver by affidavit about this seized person, and then they can be taken away. So the clause gives you the right, the law gives you how to get this person back. Okay? And then, as I said, with the Fugitive Slave Law of 1850, it just, I guess, it strengthens the punishment for those who are helping to escape. And instead of just agent or attorney, it's now saying, U.S. federal marshals, go in. This is federal law. Go in and do your job and help these people with these escaped slaves or escaped persons. Okay? Mhm. The word act and law can be interchangeable. Act, law, statute, yes.
And the third one just enhanced the second. So
Yeah.
the amendment
Well, technically, there's only two. The two that we discussed, 1793 and 1850. The clause. So first of all, we don't have a fugitive slave law anymore. I think. I'm kidding, but we don't have a fugitive slave law anymore. But there is always a fugitive slave clause that's in the United States Constitution. We just don't use it, but it's still in the Constitution to today. Like there's still a three-fifths compromise in the Constitution. There is still an 1808 clause in the Constitution. Those things will always be in the Constitution. Like you don't erase it just so you don't use it anymore. It is still there. It is just not in practice. So, but there's no law there anymore. So there's only the 1793 law, and then there's the 1850 law. Any questions about Fugitive Slave Clause, Fugitive Slave Law 1793, Fugitive Slave Law 1850? The thing about 1850, just remember that it increased punishment as far as, fines and jail time. And it charged the U.S. federal marshals with helping to get escaped slaves. Now, where is my mobile phone? Oh, right there. There's my mobile phone. It's been a long day in mediation. Sure, yeah, of course, know that. That now, I try to make the exams as easy as possible by making it multiple choice. But I told you guys that from the first day, I'm going to treat this class and teach it like a law course. By you knowing the pro-slavery and anti-slavery arguments, or the pro-South and pro-North or vice versa arguments, then it helps you think like a lawyer. It helps you get creative with your arguments, and I think it helps you choose the best answer. I'm not going to say right, but the best answer. Like this is why, okay? So let me see if I can find one of my first exams. Because I don't reinvent the wheel. What I want to do is pull some of my best questions from each of my first exams the 10 times that I've taught this class. See, let's see. I teach it every semester now. Every single semester. Okay, as I'm looking this up, any loose questions out there? I'm totally asking questions on that. Let's see if I have one of my Dred Scott questions. Hmm. So, I didn't really do a lot of Dred Scott back then. So, a Dred Scott question that I could ask is, I would say, Dred Scott versus Sanford, 1857, and I'll have a dash, much like I have like one bit, and then I have dash, and you'll have to pick the right one. And some of the answer choices are, and the answer choices change depending on how in depth I got with the case. But it'll be A, Chief Justice Taney dissenting, and that's when I used to spend a whole week on Dred Scott. So you don't know that Chief Justice Taney wrote this decision. B, rules that Dred Scott was not free because of the Fugitive Slave Law of 1850. C, expressly stated that a free Negro of the African race whose ancestors were brought to this country and sold as slaves is not a citizen within the meaning of the U.S. Constitution. D, B and C but not A, or E, all of the above. I know you can remember all that, but I'll tell you this. Was Dred Scott ruled, was he, Dred Scott was not free because of the Fugitive Slave Law of 1850. That's not why the court determined he was not free. Do y'all remember the thing? I know we kind of like rushed it, but when I was talking about this is how the Indians, or they compared the Indians to the blacks. And I say Indians, so that's what they called them in the opinion. This is how they looked at blacks in colonial America. This is how they looked at Africans in England. This is how they look at Africans under the Constitution. This is why, you remember why I was going through all those? It's to prove that black people were never considered citizens. So we didn't have a case. Remember the whole thing about standing. And I kind of explained to you guys that I have a custody case going on where father is bringing a lawsuit for custody. But what's the difference between a father and mother? Well, yeah, because it came from the baby. I saw that baby come out, it came from the mom, but you can't say that with the dad. So my client had to go get a DNA test. And that DNA test came back and they said that you are not the father, you're not conclusively the father, then does my client still have a custody case? Because he doesn't have standing. Because the law gives certain people right to bring lawsuits. And he don't fit any of those exceptions. It's more than just mother and father and grandmother, but he doesn't fit any of those exceptions. What, you have strong ties to the kid? I don't see that happening. But that's the thing with Dred Scott. It wasn't that Dred Scott wasn't free because of the fugitive slave law. Dred Scott didn't escape. Dred Scott asked the widow, hey, can I buy my freedom? And she said no. He's like, everybody else buying their freedom. Can I buy my freedom? No. So Dred Scott sued for his freedom because he was like, hey, I remember that one year that Dr. Emerson took me to the territory, and the territory is free. He took me there. And I remember this Rachel case that happened a couple years ago where, same thing happened to her. So I'm going to sue on those same grounds. He sued on those same grounds. But the court decided, and I think we talked about that after class. I didn't go in that with the class because that's not as important. But the court decided that he couldn't prove that he was a slave. Crazy, I know. The first court decided he couldn't prove he was a slave, so they threw it out. Eventually, the case went all the way up to the Supreme Court. And the big thing about it was not that he couldn't prove that he was enslaved, so therefore he could be free. He couldn't prove that he was a person who could sue. The person who can sue in federal court are citizens between two different states. So I, as a citizen of Texas, can sue somebody who's a citizen of Louisiana. Dred Scott was claiming that he was a citizen of Missouri, and he was suing for freedom from somebody who was a citizen or a resident of New York. The person who was a resident of New York was no longer Dr. Emerson because he's dead. It's not Dr. Emerson's widow because she was like, I'm tired of this. It was Dr. Emerson's widow's brother. She was like, look, take Dred Scott off my hands. You have him. So he sued the brother. That's how we get Dred Scott versus Sanford. John Sanford was his new owner. So I know we have this Dr. Emerson cat. It's like, where's his name on the title? No. He's suing two different people. But the United States Constitution says that you can sue in federal court if you are citizens. They have other exceptions where you can sue in federal court. You can sue under certain federal laws. But in order for two people to sue each other, you have to be citizens of two different states. Dred Scott was a citizen of Missouri, allegedly, and John Sanford was a citizen of New York. But if I was John Sanford's attorney, much like my attorney in the custody case, that's why I'm glad we got the DNA results back. He is the father. But the first thing that attorney would have said is, Judge, we need a pause on this case until we get some DNA results back because we don't even know if he has standing to bring this lawsuit. That's what John Sanford attorney said. That's what I'm thinking he said. When John Sanford's sitting in his office, he's saying, wait, you mean this slave brought this lawsuit against you? He's a slave. He doesn't have the right to vote. He doesn't have the right to marry. Is he even considered a citizen? You think he's on the same level with you, John Sanford? No. Forget the fact that, your brother-in-law took him into the territory at one point in time and he could be free. We're going to attack this a different type of way because we saw what happened in Rachel's case. We know that these slaves are becoming free just by going into a territory. The way we're going to attack this is say this person can't even bring a lawsuit because he's a slave. That's like saying my house or my dog or my car can sue. My property can sue. That's what he's saying. So that's the big thing that I need you to know about Dred Scott. And although you won't recognize this quote because it comes directly from the case, It's in quotations, so it's not a lie. Number one. Number two, and this is going to be the answer to the exam. If you think about it, a free Negro of the African race whose ancestors were brought into this country and sold as slaves is not a citizen within the meaning of the United States Constitution. Because remember, two citizens can sue each other if they're from different states. But a citizen and a car can't sue each other. And that's what they're saying Dred Scott was. Your property. You can't sue. And that's why we went through all of those things. I mean, we didn't go over them in depth, but I just said these are about the 6 or 7 reasons why the Supreme Court came to that decision that persons of African descent were no longer, persons born of African descent will never be considered a citizen of the United States. Because they looked at how we treated the Indians and said, okay, that's their consolation prize. We'll give them property even though we conquered them. They said that in the 13 colonies, we didn't consider them citizens because if we did, we would not have restricted their right to marry, their right to congregate, their right to move at night. We know that we didn't consider them as citizens in the United States because we didn't even call them citizens. Matter of fact, we made an 1808 clause. We made an 1808 clause that gave us the right to import them for 21 more years. We made a 3/5 compromise that said we're not going to even treat them as a whole person for tax purposes or representation purposes. We're going to only count 3 out of every 5 of them. And lastly, if we thought they were citizens, we would not have something in place for us to be able to go after them if they escape. But mind you, the Fugitive Slave Clause is still in effect because what happens when somebody escapes from TDC, from Huntsville? Under the same Fugitive Slave Clause. Mm-hmm. It's just enacted in or federal prison. Yeah, it's just enacted in different types of ways, Mm-hmm. So that would be like a Dred Scott quote. I mean, that's the big thing about Dred Scott. Not that do know that he was suing under the same thing as Rachel. I was taken to a territory by my master who was in the army. And in the army, you can't decide where you go. But I was taken to a territory by, and therefore I should be free, just like Rachel. And just think about how I'm saying, like you're sitting in my office and you're saying, look, I'm scared about this. This is what they've been deciding down in Missouri. You're John Sanford. This is what they've been deciding in Missouri, that these slaves are, they're suing for their freedom by going to free territory. My brother-in-law did it. He was stupid. He should have just not took his slave with him, but he did. So I need to know what are my chances of keeping my slave. And then the lawyer's like, that's a good question. Well, that's how they've been deciding. But let's look at this a different way. How about we say that he can't even go to court and sue? Let's bring that to the judges. That's what it was. He's not a citizen within the meaning of the Constitution. He doesn't have standing to sue.
So what's the important thing we should know about Rachel V. Walker? What's the important thing we should know about Rachel V. Walker?
That it was the opposite of Dred Scott. It didn't start it. It was actually Winnie versus Whiteside that started this whole thing of taking someone into a free territory. And by taking someone into a free territory, they are thereby free. But remember what I said about due process. The government has the right to take your life, liberty, and property, but you have to have due process. If you are going to get convicted and sentenced to death, there's no longer the days where you bust into somebody's house because you whistled at somebody and you beat them and you put rocks in their pocket and you put them at the bottom of the river. We'll probably still do it, but that's not justice. Justice in this case is you charging somebody, a grand jury coming back with an indictment. You probably taking a plea deal. I don't think anybody's going to plea deal for the death penalty, but you take it to trial. You come back with a guilty verdict. There's sentencing evidence that put on, and a jury your peers find that you are guilty and you should be sentenced to death. Yeah, your life is taken away from you, but you had due process. You had the chance to confront your witnesses, to confront the evidence. When your liberty is taken away from you, I just think about that as being put in jail, or even hell, if you go to a mental institution, your liberty is taken away from you there, but you're going to be committed at a hearing. I think most of those 5150 holds, they don't last too long. Like, that's before you have a hearing. If somebody's going to be committed for, I think it's 3 days. If somebody's going to be committed for longer than that, I think there has to be a hearing on their mental stability or instability. Your property taken away. And I always give this example just because I attended U of H when, before the train track went through Wheeler Avenue. There were houses there. And so there was something in place to say, hey, we're going to need this to put a train track there, And they weren't just like, okay, thank you for coming out to town hall. Those people got compensated, just compensation. Now, you probably can't put a price on your childhood home or a home that's been in your family for generations, but,
It was just compensation for this property that was taken away from you. So, with due process, think about it from the slave owner's perspective. First of all, think about it from not somebody who just wanted to go to the territories on vacation because they wanted to get away from the summer heat. Think about it as the two people, Dr. Emerson and Dred Scott, and I can't remember the other sergeant's name in the Rachel case, but these are two people who are employed by the military. They do not get the chance to decide, hey, I think I want to go there because my family's here. No, you take your family and your property with you. So they went from Missouri to the territories, which all the territories were free. Remember, Northwest Ordinance of 1787 says no slavery. It was like never eats out. West of like the Ohio River. Okay? So they're going to these free territories. The slaves weren't escaping. They're doing their own thing, probably still serving their service. Word on the street is when they got back, they're just like, hey, you think I can challenge this in court? I mean, because I did go to a free territory. Somebody's like, yeah, challenge it. It worked for Winnie. It worked for Rachel. It did not work for Dred Scott. Because he did use the argument, hey, I went to a free territory. But then John Sanford's lawyer backdoored and said, you're not even supposed to be here. Back to my example, my custody case. If my client hadn't got that DNA test, and we were just, the kid could have been living in a crack house with mom, you know? But if my client hadn't got that DNA test, and we're saying, but look, you know, mom's living in a crack house. The judge is saying, well, we have to decide that some other way, but you're not getting custody because you don't even have standing. Same thing with Dred Scott case. Well, Rachel, you know, went to the territory, she's free. Well, I mean, that may be true, but you don't even have standing to bring this suit. So, yeah. Okay.
They got a better lawyer.
They got a better lawyer. That's African Americans law. I mean, the longer I do this, the more I look at it and I teach it as a lawyer. I wasn't a lawyer when I started teaching this course. I was waiting on our exam results. But I think about it as a lawyer of what this person's saying. How do they attack these arguments?
How long do your results take to